Good morning, Judge.
Good morning. Billy, which case are you on?
Joseph Roland, Your Honor.
What was the last name?
Roland.
Oh, Roland? Okay, got it. Okay.
I know, because from where the elevator is on the right.
Morning. There he is.
Hey, Judge, is that APA Molnar?
It is. The one and only.
Hey, APA Molnar. I wanted to ask, do you have any objection to an adjournment in this matter? We've received the judge's order in the case, and my client is considering whether or not he wants to take a plea, or if he wants to possibly appeal the judge's order. But at this time, I think he has like about 10 days left, but he's considering the plea. Would it be okay if we just came back on this matter?
Yeah, I'm okay with it. Sir,
What's your client's name again?
Morris, he should be on the Zoom. I've spoken to him this morning.
Okay. Well, we need to set a trial date.
Sure, Your Honor. I don't think one's been set in this matter as of yet. And APA Molnar, is the misdemeanor plea still available?
yes.
Okay.
Is Mr. Morris here?
He should be on Zoom, Your Honor.
There's nobody, I don't see anybody by that name here. Devin Morris? Yeah, not yet. What's your name, sir? Okay, all right, Ms. Mitchell's your attorney? Okay.
Good morning, Judge. How are you today?
I'm fine. How are you, Ms. Callahan?
Doing well. If Mr. Zaranik's ready, Michael Taylor is here.
Okay.
I'm ready.
Calling case number 19-6885-01-FH, People State of Michigan versus Michael Taylor. Appearances, please.
Good morning, Your Honor. Sean Callahan on behalf of the Probation Department.
Bob Zaranik for Mr. Taylor, Your Honor, P 39346.
And Mr. Taylor, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell it.
Michael Taylor, Michaeltaylor.
All right, we're handling this matter on Zoom today. Are you okay with handling this matter on Zoom?
Yes.
Okay, go ahead, Ms. Callahan.
Your Honor, today's the date and time set for a probation violation hearing. We've been waiting for a competency exam from the 46th Circuit Court so that they can proceed with their new case there. I have left messages at the court, at the judge's chambers. I don't know the next court date. I'm not sure if Mr. Taylor's been notified yet.
No, I haven't.
Yeah, I did talk to Mr. Taylor a couple times, Judge, and he's still waiting to hear from his attorney and from the court about his next court date. I don't think he's even had the interview yet, though. So there's no interview, no report yet.
I think he was interviewed, weren't you, Mr. Taylor?
Yes, I was interviewed. I'm just waiting on their.
Okay, my fault.
Yes.
When was your interview?
When?
Yeah, what day?
Last year, September or sometime, I believe.
September.
I'm not sure on the exact date, but I know it's around there somewhere. I'm never good with dates.
Who's your attorney?
Seeger. Thomas Seeger.
What did you say?
Thomas Sager, or I don't know how to pronounce it.
Do you have any contact information for this person?
Yeah, I have his number. Hold on. Just give me a second while I pull it up. I got over 500 contacts, so it's gonna take a little second. All right, you ready?
Yep.
Cell phone number 231-620-4670.
And how do you spell his name?
Seeger, Seger. I believe the first name Thomas.
Um, why don't we set this for? About March 31st. Only if we'll find out some more information by then, maybe Ms. Callahan or Mr. Zaranik, you can reach out to that attorney and find out some information that apparently is eluding Mr. Taylor.
Thank you, Judge. I will.
Thank you, Your Honor. March 31st.
Yep. All right, thank you.
Okay, thank you, Your Honor. Have a good weekend, everybody.
You too.
Thank
Good
you.
morning, Judge. I see my client, Mr. Morris, on the screen as well.
Okay. Calling case number 22-62-6085-01-FH, People State of Michigan versus Devin Morris. Appearances, please.
Andrew Molnar on behalf of the people.
Good morning, Your Honor. Michael Cobb, P78658. On behalf of Mr. Devin Morris. Mr. Morris, would you state your name for the record, please? Mr. Morris?
Yes, Devin Elijah Morris.
All right, Mr. Morris, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Please state your name for the record and spell it.
My name is Devin, Devan Morris, Morris.
All right, handling this matter on Zoom today. You okay with handling this matter on Zoom?
Yes.
Okay. So I guess at this point we need to set a trial date. How about? How about June 7th?
June 7th.
Yeah.
Yeah, I think June 7th is okay, Your Honor. Could we come back for a final pretrial in 2 weeks? I was asking for possibly about April 4th for a final pretrial, Your Honor. Is the court available that day?
Yeah, hold on for 1 second. How many days to try this case?
I would say a day, Judge. Maybe 2.
I would agree, Your Honor.
Okay. All right, how many prosecution witnesses?
Just two.
And how many defense witnesses?
One maximum, Your Honor.
All right. You want to come back, you said April when?
4th, I believe it's a Tuesday, Your Honor.
That's fine, as long as you're here early, like at 8:30.
Okay, thank you very much, Your Honor.
All right, we'll see you then.
All right.
I think we're ready on Edmonds.
Mr. Gozi, is your client here ready to go?
He's here, Judge, we have a specially assigned person.
Okay. Everybody's here ready at Edmonds.
Judge, you have the police form for that.
Yes. Calling case number 22-7229-01-FH, People of State of Michigan versus Justin Edmonds. Appearances, please.
Andrew Mulner on behalf of the people.
And good morning, Your Honor. Sanford Shulman, P43230, appearing on behalf of Justin Mitchell Edmonds. He's appearing by way of video conferencing. His name is not displayed, but I see him on there, and he's consenting to participate by way of video conferencing. I've tendered to the court an executed plea form.
All right, Mr. Edmonds, please unmute yourself and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record and spell it.
Justin Edmonds, JustinEdmonds.
All right, do you read, write, and understand the English language?
Yes, Your Honor.
We're handling this matter on Zoom today. You okay with handling this matter on Zoom?
Yes, Your Honor.
All right, so you want to place the offer on the record, Mr. Mulder, please?
Yes, Judge. Mr. Edmonds would plead to an added count 3, police officer assaulting, resisting, obstructing, carries a statutory maximum penalty of 2 years. We would agree to dismiss counts 1 and 2. And there would be a sentence agreement of 2 years probation, substance abuse evaluation and treatment as recommended, mental health evaluation and treatment as recommended, forfeit all firearms to the arresting agency, cognitive behavioral therapy, and any other terms and conditions set by the court.
All right, is that a true and accurate understanding, Mr. Schulman?
Yes, Your Honor.
All right, Mr. Edmonds?
Yes, sir.
We ask a series of questions. If at some point you can't hear, you don't understand something someone says, please interrupt and let us know. And then we'll stop and go over it again and make sure that you do hear and you do understand, okay?
Yes, sir.
And if you're asked a question and you give an answer, I'm going to assume that you understood the question and the answer that you gave was the answer you intended to give. Fair enough?
Yes.
Have you heard and understood everything so far?
Yes.
All right, how old are you, sir?
39.
And how far have you gone in school?
Some college.
Are you a United States citizen?
Yes, sir.
I have a form in front of me entitled Settlement Offer, Advice of Rights, Notice of Acceptance, and it contains the plea and sentence agreement that was just placed on the record. Have you seen that form before?
Yes.
And did your form and its contents fully with your attorney, Mr. Schulman?
Yes.
Did he explain the plea and sentence agreement to you?
Yes, sir.
Did he answer all your questions?
Yes.
Did he explain to you the rights that you're giving up by pleading guilty?
Yes, sir.
And did you authorize him to sign that form on your behalf?
Yes, sir.
Did anybody force you to do that?
No, sir.
And did anybody promise you anything other than that which is contained in that form?
No, sir.
Now, do you understand what this plea states? A statutory maximum penalty of 2 years in prison.
Yes, sir.
And do you understand if you were to proceed to trial and you were found guilty as charged, you'd have to face You have to serve a mandatory 2 years in prison on the felony firearms, and then up to 4 years in prison on the felonious assault thereafter. Do you understand that?
Yes, sir.
And are you satisfied with Mr. Schulman's representation of you?
Yes, sir.
You understand you have the right to a jury trial, which 12 impartial jurors would decide whether you're guilty or not guilty of any crime charged.
Yes, sir.
You understand you can give up your right to a jury trial and allow me to sit as the fact finder to determine whether you're guilty or not guilty of any crime charged.
Yes, sir.
You understand you have the right to be presumed innocent until proven guilty.
Yes, sir.
You understand you have the right to have the prosecutor prove your guilt beyond a reasonable doubt.
Yes, sir.
You understand you have the right to have witnesses against you appear at trial to testify.
Yes, sir.
You understand you have the right to question and cross-examine those witnesses through your attorney, Mr. Schulman.
Yes, sir.
You understand you have the right to call your own witnesses to court.
Yes, sir.
You understand you have the right to have the court subpoena or summon witnesses on your behalf, requiring them to appear.
Yes, sir.
You understand you have the right to remain silent at a trial. You cannot be compelled to testify.
Yes, sir.
You understand you have the right to not have that silence used against you. So in other words, if you decided to proceed to trial and not testify, I would instruct the jury that they could not hold that silence against you.
Yes, sir. Yes, sir.
You understand you have the right to testify on your own behalf if you so choose at a trial and tell your version of the facts.
Yes, sir. Yes, sir.
You understand that by pleading guilty, you're giving up all the rights that we've just reviewed.
Yes, sir. Yes, sir.
Other than the plea agreement and sentence agreement that have been placed on the record, has anyone promised you that you plead guilty?
No, sir.
Has anyone threatened you, coerced you, in any way forced you to plead guilty?
No, sir.
You understand that if I accept your plea, I'll be giving up any claim that your plea was the result of a promise or a threat unless you tell me about it right now.
Yes, sir.
Are you pleading guilty voluntarily and of your own free will?
Yes, sir.
Are you currently on probation or parole?
No.
You understand that by pleading guilty that you're giving up your right to appeal your guilty plea as of right, and even though the Court of Appeals may grant you leave to appeal, it is by no means obligated to do so.
Yes, sir.
You understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir. I understand.
All right. And to Mr. Schulman and Mr. Molnar, are either of you aware of any promises, threats, or inducements other than those already disclosed on the record?
No, Your Honor.
No, Your Honor.
Okay. Mr. Molnar, would you please create a factual basis?
Yes, Judge. Mr. Edmonds, on November 9th, 2022, were you present at or near 658 Ford Avenue?
Yes, sir.
Set in Wyandotte, Michigan, County of Wayne?
Yes.
Okay. And on that day, were you in some sort of altercation?
Yes.
And were the police called during that altercation?
Yes.
Okay, and when the police arrived, were you inside the house?
Yes.
Okay, did you hear them outside?
No, I was unconscious, sir.
Okay, so did you ever see the police?
Not until I walked outside, no.
Okay, and when you walked outside, did you see them?
Yes.
Okay, did you run away from them, at least at first?
No.
You never
hold on.
ran down the street westbound?
Mr. Edmonds, do you understand you're pleading guilty on this case? Do you want to have a trial? Or do you want to take a plea?
No,
It's up to you.
no,
It's up to you.
I want to take this plea and get it done.
Okay, but you can't just get it done. You have to make a factual basis. So if you're saying you didn't do anything that impeded the police from arresting you, then
I got you.
we went over this yesterday, remember?
Yes, I apologize. I'm just a little confused, nervous.
That's okay.
Yes. To your question, yes.
Okay, the people are satisfied then, Judge.
Defense is satisfied, Your Honor.
Have I complied with Court Rule 6.302?
You have, Judge.
Yes, Your Honor.
I find that Mr. Edmonds' plea is understanding, voluntary, and accurate. I'll accept his guilty plea. He'll be referred to the probation department for a pre-sentence investigation report. And how about if we set a sentence date of April 21st?
Fine.
Does that work for you, Mr. Schulman?
It does. Thank you.
All right, so Mr. Edmonds, you're gonna have to contact the probation department to set up an appointment for a pre-sentence investigation report interview. You have a piece of paper and a pen?
I certainly do, sir.
I need you to call this number. 313-224-2600. I need you to call that number today to set up an appointment for a pre-sentence investigation report interview. If you're having difficulty getting through, just keep calling until you get that appointment set, okay?
Yes, sir.
And we'll see everybody here on April 20th at 8:30.
May I ask just a question though? I'm a little confused. With accepting the plea and all that. I didn't realize I would still have to come and see you afterwards.
We have a sentencing
Yes.
date. I explained to this, gonna be a pre-sentence.
That's when you learn.
Oh, okay.
All right.
Okay. Yeah, I understand. I'm sorry. I was just confusing and nervous. I've never, been in court before.
Okay. And I'll follow up with you, but thank you, Judge.
All right, thanks. Have a good day. Anybody else? You ready? Yes. Mr. Goes, you're still waiting at your prosecutor. Yes, sir. Okay, calling case number 19-7487-01-FH, people of state of Michigan versus Cindy Chisholm, appearances, please.
Andrew Molnar on behalf of the people.
And good morning, Judge. I'm Christopher Sinclair, the 80512, appear with on behalf of the Chisholm. Follow me to the podium right now.
All right, and ma'am, please state your name.
Cindy Chisholm.
All right, good morning, Mr. Chisholm, Mr. Sinclair, and Mr. Molnar. Is there a resolution in this case?
There is, Judge. Do you not have the plea form?
I don't.
In the meantime, Judge, I just to Mr. Fox and Mr. Kolowski. But the resolution is for Ms. Chisholm to plead to count 2, assault with intent to do great bodily harm, which carries a statutory maximum penalty of 10 years. The people would agree to dismiss count 1, assault with intent to murder. And there would be a sentence agreement of 2 years probation with the first 12 months in the Wayne County Jail, anger management, substance abuse evaluation and treatment if recommended, and any other terms and conditions set by the court. And we are not objecting to a no contest plea due to lack of memory.
Okay. Is that full and accurate understanding, Mr. Sinclair?
Yes, sir.
All right, ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, please state your name for the record and spell it.
Cindy Chisholm, CANIDUECHISM.
All right. Can you read, write, and understand the English language?
Yes.
All right. Ma'am, you'll be asked a series of questions. If at some point you can't hear, you don't understand something someone says, please interrupt and let us know. And then we'll stop and go over it again to make sure that you do hear and you do understand, okay? And if you're asked a question and you give an answer, I'm going to assume that you understood the question and the answer that you gave is the answer you intended to give. Fair enough?
Yes.
All right. Have you heard and understood everything so far?
Yes.
All right. How old are you, ma'am?
39.
And
I'm
how far-
38.
Okay. How far have you gone in school?
Some college.
Are you a United States citizen?
Yes.
I'm holding in my left hand a form entitled Settlement Offer, Advice of Rights, Notice of Acceptance, and it contains the plea and sentence agreement that was just placed on the record. Have you seen this form before?
Yes.
And did you review this form and its contents fully with your attorney, Mr. Sinclair?
Yes.
Did he explain the plea and sentence agreement to you?
Yes.
Did he answer all of your questions?
Yes.
Did he explain to you the rights that you're giving up by pleading guilty?
Yes.
And did you authorize him to sign this form on your behalf?
Yes,
Did anybody force you to do that?
no,
And did anybody promise you anything other than that which is contained in this form?
no,
You understand with this plea, you face a statutory maximum penalty of 10 years in prison.
I'm sorry,
You understand with this plea, you face a statutory maximum penalty of 10 years in prison.
yes,
And you understand if you proceeded to trial and you were found guilty as charged, you could face up to life in prison.
yes,
And are you satisfied with Mr. Sinclair's representation?
yes,
You understand you have the right to a jury trial, which 12 impartial jurors would decide whether you're guilty or not guilty of any crime charged.
yes,
You understand you can give up your right to a jury trial and allow me to sit as the fact finder to determine whether you're guilty or not guilty of any crime charge.
yes,
You understand you have the right to be presumed innocent until proven guilty.
yes,
You understand you have the right to have the prosecutor prove your guilt beyond a reasonable doubt.
yes,
You understand you have the right to have witnesses against you at peer trial to testify.
yes,
You understand you have the right to question or cross-examine those witnesses through your attorney, Mr. Sinclair.
yes,
You understand you have the right to call your own witnesses to court.
yes,
You understand you have the right to have the court subpoena or summon witnesses on your behalf, requiring them to appear.
yes,
You understand you have the right to remain silent at a trial. You cannot be compelled to testify.
yes,
You understand you have the right to not have that silence used against you. So in other words, if you decided to proceed to trial and not testify, I would instruct the jury that they could not hold that silence against you.
yes,
You understand you have the right to testify on your own behalf if you so choose at a trial and tell your version of the facts.
yes,
You understand that by pleading no contest, you're giving up all the rights that we've just reviewed.
yes.
Other than the plea agreement and sentence agreement that have been placed on the record, has anyone promised you anything so you plead no contest?
No,
Has anyone threatened you, coerced you in any way, forced you to plead no contest?
no,
You understand that if I accept your plea, I'll be giving up any claim that your plea was the result of a promise or a threat, unless you tell me about it right now.
yes,
Are you pleading no contest voluntarily of your own free will?
yes,
Are you currently on probation or parole?
no,
You understand that by pleading no contest, that you're giving up your right to appeal your no contest plea as of right, and even though the Court of Appeals may grant you leave to appeal, it is by no means obligated to do so.
yes,
You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
yes.
And to Mr. Molnar, Mr. Sinclair, either of you aware of any promises, threats, or inducements other than those already disclosed on the record?
No, Your Honor.
No, sir.
All right, is there an agreement to use the investigator's report for the factual basis?
Yes, Your Honor.
Mr. Molnar, would you please create the factual basis?
Yes, Judge. On May 9th, 2019, at the location of 20066 Hamburg, which is in the city of Detroit, County of Wayne, Miss Chisholm and Miss Roseanne Cross were together. They were, drinking alcohol, inebriated. They arrived back at Miss Chisholm's home, and when they were walking up to the home, the defendant, Miss Chisholm, struck Miss Cross in the side of the head. Miss Cross then fell to the ground, and Miss Chisholm then stood over top of her and began striking her with punches and also kicking her with their feet. The victim, Miss Cross, then passed out and woke up the next day in the hospital.
Satisfied, Mr. Sinclair?
Sure.
Now we comply with Court Rule 6.302.
Yes.
Find that Ms. Chisholm's plea is understanding, voluntary, and accurate, and I'll accept her guilty plea. She'll be referred to the probation department for a pre-sentence investigation report. It will set a sentencing date of April 21st. Does that work for everybody? Okay, so ma'am, when you leave here, you need to go to the probation department to set up an appointment for a pre-sentence investigation report interview. So when you come out of the front of the building, the street on your right is Clinton Street. You're right on Clinton Street, go down about a block and a half past the Harbor House Restaurant to 426 Clinton Street. That's where probation is, and that's where you need to set up an appointment, okay?
Okay.
If you have any questions, my deputy has a map. All right?
All right, thank you so much, sir.
Have a good weekend.
already. Yeah.
Are you and Mr. Reed on the same page?
Yes, we are.
It's not good.
Who's here? Both our clients are here.
Is that up there?
No, let's wait to the.
Let's see. We ready on Axon?
Ready, Judge.
Calling case number 22-7268-01-FH. People of State of Michigan versus Jonathan Axon. Appearances, please.
Andrew Molnar on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Mr. Axon, who's also present in the courtroom. Mr. Axon, can you please state your name for the record?
My name is John.
Morning, Mr. Axon, Ms. Phelps, and Mr. Molnar. So this was continued for the judge hearing date of the motion to quash. Mr. Axon is charged with operating under the influence causing serious injury, operating under the influence, well, two counts, reckless driving causing serious impairment of a body function, two counts there. And then I think the remaining counts were dismissed. Is that right?
Yes,
Yes.
Judge, the operating with license suspended will be dismissed.
Okay. So I believe I indicated at our last hearing that I, based upon the record that was created, denying the motion to quash as to operating while intoxicating under the influence causing serious injury. And the only issue for today was whether or not motion to quash relative to the reckless driving causing death should be granted. In reviewing the record and case law, the only argument I think that can be made as to reckless driving causing death would be that the defendant having a BAC of 0.19 and driving constituted willful or one disregard of the health and safety of others. The problem is there's no case law that would appear to suggest that sort of fact pattern. In all the other cases that the court has seen, there's some evidence of driving. There's excessive speed, there's weaving in and out of traffic. In this case, we don't have any such testimony at the district court. There's evidence that he's driving because there's a collision and he's in the car alone at the front floorboard, and certainly a serious injury. And we know that he had a high BAC, but other than that, there's no evidence of how he was driving. With operating under the influence causing serious injury, there's no element that one has to show bad driving. One just has to show that there was a blood alcohol level in excess of the legal limit, that there was an accident, and that there was a serious injury. With reckless driving, there has to be some element, I believe, of driving in a way that is willfully, wantonly, that willfully wantonly disregards the health and safety of others, and it just doesn't exist on this record. So for that reason, I would grant the motion to quash as to the reckless driving causing serious impairment of the bodily function.
Thank you, Judge. That's count 3 and
Right.
So this is set for a jury trial in a month from today. Can we have another final conference in a week? I have to speak with my supervisor, but I think there's a chance that we dismiss this and refile it and go back to the exam stage.
Okay.
So to talk to them, I have to talk to these folks. But, you know, it's set for jury trial, so if we don't, but it's
Right. Well, a week from today is bad for me, but if you wanted to come in like the 23rd, that's fine.
can I just have one moment to speak with the prosecutor? I know. Your Honor, I think that after discussion, if we could have 2 weeks to come back to see if there's any possibility of resolution, or if they're gonna make their dismissal. We could figure that out before those 2 weeks, but we could come back in 2 weeks for a final conference.
All right, you want to see March 31st?
I think I'm gonna get a trial. Can we do the 3rd? Maybe, actually, let's just do the 31st.
Okay. See you on the 31st?
Thank you, Judge.
thank you, Judge.
Mr. Gozi, you ready?
We're ready, Judge.
Yes, we're ready.
We're ready. Yeah, we're ready.
Mr. Reed, Mr. Cripps was just here.
Yes.
You want to grab him? I'll take you right after I handle this.
Okay.
Yeah, I mean, he was just here just a few minutes ago.
Okay.
Calling case number 21-1457-02-FC and case number 19-9028-01-FH. People, State of Michigan versus Derek Boozer. Appearances, please.
Dominic DeGrazia on behalf of the people.
They're getting Mr. I'll wait till.
All right. I guess I failed to realize he
That's
was in
okay.
custody. Since Okay, calling case number 19-9028-01-FH. And case number 21-1457-02-FC, People of the State of Michigan versus Darren Boozer. Appearances, please.
Dominic DeGrazia on behalf of the people.
Good morning, Eric Gozzi on behalf of Mr. Derek Boozer.
Sir, please take your name.
Derek Boozer.
Right, good morning, Mr. Boozer, Mr. Gozzi, and Mr. DeGrazia. Today's the date set for sentencing, case number 21-1457-02-FC. Actually, as well as the other case as well. Mr. Gozzi, have you had a chance to review the pre-sentence investigation report and sentencing guidelines with Mr. Boozer?
Yes, sir.
Do you have any changes, additions, or deletions to the pre-sentence investigation report?
Yes, I do.
What do you got?
With respect to the, his biological information, he indicates to me that he did in fact achieve his high school diploma, correct? sir? It's mentioned that they say that he failed to achieve his high school diploma or GED, but he assures me that he did in fact get his high school diploma.
Where?
Charlotte Fort Academy.
I'm sorry?
Charlotte Fort Academy. Charlotte Fortune Academy.
Well, hold on.
Sorry.
Okay.
And it's interesting to note, because also under the education section, it says Charlotte Fortune Academy Certificate High School Diploma. Yet right below that, they go on and say he only completed the 11th grade. So that doesn't quite make a lot of sense, but.
Right, it's that, yeah, and then that same sort of line, it says 11th grade.
Right. Secondly, he actually has two children. He has Alyssa Johnson as well as Madison Jones. Madison is erroneously taken or not accounted for on this, and that's also under the section heading marriage. So we asked that Madison Jones be placed as another child.
Madison Jones.
Correct. She's 11 years of age.
And where does she live?
Well, right now, Nashville, Tennessee. Judge, and Alyssa also should be Nashville, Tennessee,
Not
not
Michigan.
Nashville, Michigan.
Got it, okay.
Lastly, with respect to the guidelines, I've had an opportunity to discuss this matter with the people. We are in agreement that the PRVs are correctly scored at 42 points total.
Okay.
That PRV 1, 2, 4, and 6 are correctly scored as noted in the report.
Okay.
That the offense variables, 1 is correctly scored at 25, 2 is correctly scored at 5, 3, the people and I are in agreement should be scored at 25 points, not 100.
Is that right?
Yes, Judge.
Okay.
We believe that OV4 is correctly scored at 10 points. We agree that we disagree with the probation department's report of OV5 at 15. It should be scored at 0 points, correct, Ms. Preston?
Yeah.
Offense variable, ready? Number
Yeah.
6 should be scored at 25 points. And offense variable 9 should be scored at 0 points,
I agree to that, Judge.
giving him a grand total of 90 points. Putting him on this, on the grid of the A grade as being a D5, making his overall guideline scoring of 135 to 225 points. Without the conviction, of course.
Okay.
With that, we ask the court to follow the sentence agreement that we've entered into. I believe that the prosecuting attorney for the other case that's still pending, I've spoken to him, which was not part of this package deal, plea offer, is going to move to dismiss that felonious assault charge. Unfortunately, Mr. DeGrazia did not have a confirmation of that prior to today's date. So I'm hoping he'll be up here shortly, so we may be recalling this case in any event. That's all I have to say. I don't, is there wants to allocate this time? Did you want to say anything on your behalf, sir? Oh, and lastly, one last thing, thank you for reminding me. With respect to restitution, there is not a set amount that's in place yet. We anticipate the victim of the case will have medical needs to be taken care of as he was paralyzed as a result of this injury. However, we would ask the court to consider the following. Rather than making restitution while he's in prison for the next 6 years as a condition of the plea, of his sentence, if it could be made a condition of release from parole, so that restitution will be assigned once he gets out of prison, hopefully 6 years. And then he can start making payments. Otherwise, the meager amounts that he does get while he's incarcerated, I think 50% automatically gets taken out, goes towards court costs, fines, and fees, as well as any restitution amounts, which would ultimately leave him with maybe $10 a month to survive on while he's incarcerated. So we would ask the court to consider that. And one last thing I forgot to mention. The dates that they calculated, they have it up until 16th of March 9th, which on the cover sheet, I think it's on page 2.
Right.
It should be an additional 8 more days, Judge. Because today is the 17th, giving him a grand total of 785 days.
Mr. DeGrazia?
Well, Judge, just in terms of the restitution, there is no restitution that's being ordered at this time, as far as I can tell. But if there ever were to be an order, I would ask that that be part of the defendant's sentence, even if he's in prison. I mean, there's no guarantee the defendant will ever pay him any money once he's released from prison. So I'd at least prefer to have some money going to the victim if that's ever ordered.
Well, I mean, how soon until you'll know whether or not there's restitution?
Quite frankly, I don't know if there will ever be a restitution. You know, this could be the subject of a civil lawsuit, if you ask me, but I can certainly try and follow up and see if he can have documentation, but I didn't have that information at the time of the plea, and I don't have it now. So again, we're all talking hypotheticals here about what might happen, but I don't think the defendant is deserving of special treatment. I guess that's what I'm saying, relative to other defendants in similar situations. But in regards to sentencing, obviously I'm asking the court to adopt the sentencing agreement. I have spoken with the victim on this case a number of times, obviously well known to the defendant. This person's life, he was a young man at the time of this event, forever changed. I mean, even coming to court and sitting here for a sentence or to testify, that's a huge physical burden for him, even today. And we're talking now years later since the shooting itself. So obviously, the defendant was not held responsible for the decedent, the other victim that died. Putting that aside, the defendant is responsible for causing the permanent paralysis of the complainant. So this is obviously a very tragic event. And I think that the sentence is appropriate, and I'd ask the court to adopt the sentence agreement.
All right, and do you have an issue with the pre-sentence investigation report and sentencing guidelines as they've been amended?
No, Judge.
Mr. Fuser, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell it.
Derek Boozer, DERRICKBOOZER.
All right, do you read, write, and understand the English language?
Yes.
All right, have you had a chance to review the pre-sentence investigation report and sentencing guidelines with your attorney, Mr. Gozi?
Yes.
And do you have any changes, additions, or deletions to the pre-sentence investigation report other than what we've already talked about?
No.
You find it to be now factually accurate?
Yes.
Did you have any issue with the way the sentencing guidelines are calculated?
No.
All right, anything else, Mr. Gozi or Mr. DeGrazia? And I take it that no oral impact statement at this point?
No, Judge.
With that, it's a sentence to the court that Mr. Boozer be sentenced to 6 to 20 years in the Michigan Department of Corrections, consecutive to 2 years on count 2, felony firearm. And additionally, you shall pay $136 state costs of crime victims assessment, the amount of $130. You're to pay court costs in the amount of $1,300. The state court administrator's office has determined that $1,300 is the average cost of this court of a case that proceeds through it. We cover salaries and benefits for court personnel, goods and services necessary for the operation of the court, and necessary expenses for the operation and maintenance of court buildings and facilities. Restitution shall be determined within 365 days. And Mr. Gozi,
I'll wait turn to the judge, because restitution is really going to be something more important than anything in housekeeping pay. So I'd ask.
Okay, how long have you practiced criminal law?
22 years,
And how many hours have you put in this case?
50, 60 hours, and plus Mr. O'Donnell has been practicing 45 years. And I would charge about $225 for being a public defender. Again, yeah, it doesn't make any difference.
Okay.
But I understand.
All right, understanding Mr. Gozi's education, training, and experience level of effort, he's put in this case, even if I dramatically cut his hourly rate, $400 would still be a bargain, so $400 in attorney's fees. All costs and fees are due at the time of sentencing unless otherwise indicated. Mr. Boozer, it's my duty to advise you on the right to request leave to appeal from the Court of Appeals. If you're unable to afford an attorney to prepare post-conviction motions or perfected appeal, this court will appoint an attorney for you at public expense. They'll provide that attorney with such portions of the transcript as that attorney may require to prepare post-conviction motions or perfected appeal. To further advise that you to file an appeal or motion and request the appointment of an attorney must be made in writing. File with the clerk of this court within 42 days of today's date. Mr. Boozer, do you understand your appellate rights?
Yeah.
Do you have any questions about your appellate rights?
No.
All right, and as it relates to the 19 case.
Judge, I can stand with the sentencing. I mean, he's receiving a prison sentence. The court just wants to, I'm not sure if there was a sense agreement or not. But
When I spoke to the prosecuting attorney on that case, Judge, he indicated that he was going to move to dismiss.
oh,
If you wanted to verify
pending case or the case that he's awaiting sentencing?
pending.
Oh,
This looks like a probation matter.
Oh, excuse me, Judge. I thought that we were talking, you had 2 cases from 2019. With respect to that, yes, I would wholeheartedly agree with the prosecution. Since it's a probationary sanction, it's going in the Michigan Department of Correction.
so, yeah, the court wants to send him to time served. I have no objection.
I'll just close it out without a.
Thank you.
Okay.
And I believe that there was also a case part of the plea agreement was to dismiss the other charge. Is that correct, sir? The other case?
Yes, and he also had a,
Pending CCW. There's a case on our plea agreement.
yes, Judge, there was also, as part of the sentence agreement, we were going to dismiss case 19-902801 FH.
No objection, Judge.
Oh, okay, all right, that is, okay. All right, that case is dismissed then, sorry. I thought that was a probation matter.
Okay, that's why our confusion came in.
19-9028, that's just being dismissed.
Yes.
All right, we'll dismiss that one.
And he does have one outstanding case that's still before Judge Green. I spoke to the prosecutor on that matter. He indicated to me to come down this morning and move to dismiss that case today. So if we could keep Mr. Boozer here before we call that case.
Okay.
Thank you.
You got it. You ready on Alan and?
Ready.
Calling case number 23-000-260-0-1-FC, People of State of Michigan versus Gregory Allen. And case number 23-000-260-02-FH, People of State of Michigan versus Aricia Phelps. Appearances, please.
Andrew Molnar on behalf of the people.
Morning, Your Honor. This is what Daniel Reed can real message.
Gregory Allen. Good morning, Judge David Cripps, P 34972, appearing on behalf of Aricia Gabriella Phelps. Tell the judge your name, please.
Good morning, Judge. Aricia Phelps.
Good morning, Mr. Cripps, Ms. Phelps, Mr. Allen, Mr. Reed, and Mr. Molnar. So I think we're here for a motion to quash the Phelps matter. Cripps. You
Yes,
want
sir.
any oral argument?
Yes.
Go ahead.
Judge, my client was found over on felonious assault, underlying felony, firearm count, and resisting arrest. I wish to focus my argument on the felonious assault, felony, firearm. I believe the testimony throughout the exam, and it was a long one, but I think it's pretty clear that anything that my client did, she was acting in self-defense out of concern for the co-defendant here, Mr. Gregory Allen. This is a neighbor situation that occurred. And as you've read, my client came outside along with the co-defendant. And there was an altercation that I believe was initiated by the complainant in this case. And then Mr. Allen was confronted by the complainant. And so Mr. Allen, I believe the initial assault was started by the complainant. So Mr. Allen didn't want to harm him with a firearm or anything. So the firearm he had for his own protection, he handed to my client, and he proceeded to get into a fist fight with a man who probably easily say, based on the record in the transcript and what I saw in the courtroom, is at least twice the size of Mr. Allen. So it's easy for you to figure out from the transcript that large man was getting the best of Mr. Allen. And my client, out of love and concern for Mr. Allen, I believe used that firearm just to prevent death or serious harm to Mr. Allen at the time. It might have been pistol whip to the head, nicking him in the head, as he said, the complainant. But she did that, as you can see from the transcript, just to prevent his death or serious harm. So she was acting in lawful self-defense of her loved one, Mr. Allen. And that's, I believe, what the case is all about. And in fact, Judge, on page 17 of the transcript, which is the only part of the transcript I want to cite, because I know you've read the transcript thoroughly.
So I'm looking at page 10.
The complainant says, she got the gun and she stuck to the side. Now I appreciate the fact Mr. Allen told her to shoot me, shoot this motherfucker. She wouldn't do it. This time, then she said, he said, give me the gun. He tried to get the gun and she refused to do that. So she's diffusing the situation. And so, Judge, I don't see how there was a bind over on this felonious assault, felony, firearm. I know that you're going to read to me that there were shots fired later on, but he candidly admitted by the time we got done with cross, is he just heard the shots. He didn't know who was firing the shots. And I'll listen to the part.
In my notes, I thought the testimony was that Mr. Allen kicked Waters in the chest. That was the initiation of the confrontation.
Well, it may have been, but from my perspective, it doesn't change my argument here. Because if they're in a mutual fist fight going on and the larger man is getting the best of Mr. Allen, and my client sees that there could be some serious harm done to her loved one, she was just acting in protection, saving his life. And that's why she did a minimum amount that she could. In other words, she didn't shoot the guy. She refused to do that. She used the gun just to hit the man in the head. And it had the intent of doing what she intended, which is the complainant got off the top of Mr. Allen and stopped beating him as he was. So if the intent there on her part was just to prevent death or serious harm to Mr. Allen, and she did the minimum amount that she thought she needed to do, which is to hit him in the head with the gun, we believe that's a lawful self-defense and for the actions that she took. It's right there in the transcript. And you can weigh defenses can be weighed at the exam. And in People versus King, the Supreme Court clearly said that defense, it's a duty of the judge at the exam to weigh defenses. And I think it's clear she was acting in self-defense.
Right, well, I mean, certainly, I mean, according to the transcript, he's saying, shoot the.
He did say that, but she refused to do that.
Right, and then she hit the defendant, or excuse me, Mr. Waters in the head with a gun.
Yes, to prevent.
And then there was also some gunshots.
Doesn't know who shot him. Complaint doesn't know who shot him. Who shot those gunshots as he's running away?
Wasn't there some testimony, though, that at least did Mr. Waters testify that the gun was pointed at him in the last page 19? He testified that the gun was pointed at him and he called the police and made a police report.
Not my client, though. As I read it, starting on page 18, how do you know who had the gun at that point? Because he wrestled her when he got it. He wrestled her, and when he got it, I've been saying is I was turning the corner. That's when the shot went off. So the he I read is referring to Mr. Allen, not my client, Ms. Phelps.
All right, Mr. Mulder?
Judge, I know you've reviewed the transcripts and I've, heard the instances from the transcripts that you pointed out, and, I would agree with those instances indicating, I mean, there's testimony that, at multiple points, Ms. Phelps held the gun. At least in one point, Ms. Phelps pointed the gun at the victim. She approached him and hit him with the gun. I agree with what Ms. Murad said in her argument for bind over at the end. That the court would have to find that there is no question of fact, right? That no jury on the face of this planet would find those defendants guilty of the crimes they were charged with in order to not bind over. I do think there is a self-defense argument that can be, hashed out at a potential trial. But unfortunately, I do think that a question of fact has been created by the testimony. And the self-defense argument is not so overwhelming and clear that there's no way that, a jury could find Ms. Phelps guilty of felonious assault.
I'm glad Mr. Mona read into the record. That clearly is not the standard at a preliminary examination. Is whether there's probable cause to believe the elements have been established. And on top of that, the judge's duty to weigh any defenses such as self-defense at the exam. The issue of whether a jury would ever convict beyond a reasonable doubt or not is not something that the judge should be considering at the exam.
Well, So I guess, Mr. Cripps, if I were to believe the testimony, or at least weigh it, the light most favorable to the people, or sort of take it at its face that Mr. Allen initiated the fight with Mr. Waters by kicking him. Fight broke out, and then Miss Phelps is striking Mr. Waters with a handgun. Couldn't a jury conclude that by striking him with a handgun, she could either be assisting Mr. Allen in the self-defense, or she could be committing an assault with a dangerous weapon, where she didn't shoot him, but you don't have to have a golf club, a baseball bat, anything can be a dangerous weapon, depending on how it's used.
We don't dispute she assaulted. We're saying she did it out of the intent of protecting his life, protecting him from great bodily harm.
Right, but given those two competing arguments, or those competing views, couldn't a rational trier of fact conclude that it was, assisting in the assault rather than assisting in providing self-defense?
I think if we logically look at the circumstances, she wasn't looking for a fight. She could care less about the complaint, as you can read the transcript. But what would happen here, once that much larger man, maybe some 300 pounds, was pummeling Mr. Allen, she took the course that she thought at that time was the least intrusive in terms of causing harm, which is hitting him with the gun as opposed to shooting him or anything of that nature. And so I think we can easily infer that was her motive, to protect him. We know that because as soon as the big guy cut off Mr. Allen, he took off running. She did nothing with the gun at that point. In fact, it was wrestled away from her by Mr. Allen. If she really had an intent to harm him, she could have shot him when he got up. She could have shot him when he ran away. She could have pursued him with the gun. She did none of that. So the logical inference there, she did what she needed to do to protect her loved one's life.
I mean, Judge, the testimony, at least from Mr. Waters, is that, Mr. Allen kicked him, accused him of doing something in the past, approached him, and as they got into a scuffle, he gave the gun to Miss Phelps. I mean, sure, there's an argument maybe at trial that the fight turned into, Mr. Waters totally overwhelming Mr. Allen, but, based on the testimony, it seems like there's an argument that she was assisting him in this assault.
Well, I think it's a close call. And I do see that there's a factual dispute based on the record. I don't think that there was an abuse of discretion. And I think Mr. Cripps makes a very good and solid self-defense argument. Ultimately, I don't think there's an abuse of discretion such that rational prior fact could not find that this was felonious assault. So those reasons I would deny the motion. You want to set another trial date, Mr. Cripps?
I think we need to.
You didn't file any motion, of course, Mr. Reed.
Your Honor, we would indicate on our behalf that we still want the opportunity based upon this court's decision now to go to the gun board. I'm talking to the prosecutor.
Sure.
I join in Mr. Reed.
Okay. Let's say like April 14th.
What's it, 14?
Judge, I'm out of town that week. Sorry.
About maybe like April 6th. That's probably a bad day for you, Mr. Cripps. Um, you go the week of the 10th?
Yes.
We're in trial that next week on the first trial, so. of course, so you- 17th to the 20th.
We just need enough time for the gun board
That's true.
to consider.
Just 21st is out.
Yes, Your Honor.
April 24th.
It's fine for me.
That's fine. All right, we can do that. All right, we'll celebrate April 24th. All right.
Thank you, Your Honor.
Thank you, everyone. Have a nice weekend.
You too.
Calling case number 23-000-260-02-FH. Information regarding this mountain, case number 23-000-260-01-FH. Mr. Perkins, you ready?
Yes.
No. Now, there's two defendants, and I can only record on one. Mr. Perkins is okay with it? Who do you have, Mr. Miles?
I was gonna ask for.
Calling case number 23-000-064-01-FH, People State of Michigan versus Ibrahim Miles. Appearances, please.
Good morning, ma'am. Please, this honorable court, Rena Mitchell appearing on behalf of Mr. Ibrahim Miles, who's standing to my right. Please state your name.
Good morning, Mr. Miles, Ms. Mitchell, and Mr. Molnar. So today's the date set for final conference. Where are we at, Ms. Mitchell?
Your Honor, we do have an offer from the people. My client is, he wants to avail himself of that offer. However, he needs to take care of some family matters. He has young kids that he's the sole provider for. They live with him. The mother lives out of state, and also his brother lives with him, Your Honor. So he just needs a little time to get his family together. It's a 30-day jail sentence.
Well, I mean, if you want, we can take the plea today, and I can set the sentencing is going to be at least 30 days. So I can set it out like 45 days if that's what you want.
I'm sorry. The ink pen was throwing me off. I'm sorry.
In other words, we can set the sentencing date out, right?
Right.
It's going to be at least 30 days before sentencing because he's out of custody.
Your Honor, we just need more time because now he's acting, can he just do weekends in jail and everything?
I don't really know where to take the key.
I don't think the court has.
I don't think they do it in.
That's to check to see if work release was still available as well, but I don't think that's available.
It's not. I mean, I believe me, I like it. I've used it in the past, but since the pandemic, it's not benefit.
So he just wants a little more time to find a place for his kids to go.
Right. Like I said, if you want, I could set the sentencing for how much time do you need, sir?
School. June. School.
Mr. Molnar?
Judge, it's the minimum 30-day jail sentence for an OWI third.
Right, I can't reduce that due to the statute. I think.
Right, it's possible.
That's the only thing.
I mean, I guess I'll leave to the court's discretion. That's, definitely more time than typical. But I certainly understand Mr. Miles' worry.
I guess
Right,
my,
he was contemplating on just setting it for trial, and, you know, I don't want him to do that just because he's trying to get more time to.
Right.
Find a place for his kids to go, Your Honor, so
yeah,
we would just ask that the final conference is adjourned out, we take the plea on the next date, and then send it to him.
yeah, I guess I'm gonna have an issue. Are you on an alcohol tether?
No.
Yeah, this is what I mean, I can set the, sensing out to June, but I want him on an alcohol tether. That way he can take care of his kids, and I'll be assured that there's not drinking in the meantime. Put together the plea form and I'll recall this matter. All right, let me know when you're ready.
I think we have it done.
You guys,
I think it was sent during AOI.
I'm gonna handle some other matter while you get.
Oh, perfect, Judge, no worries.
Excuse me, Your Honor.
Yes.
I had a ride last night to court, but they informed me they had a funeral. I haven't been able to get in contact with my lawyer. She's not answering the phone. I don't see her in the courtroom either. I have a ride, but it's not till after 12.
Or she called.
It's a sentencing.
We'll wait till your attorney gets here.
Okay.
Calling case number 19-8926 -01-FH, People State of Michigan versus Christopher Smith. Appearances, please.
Good morning, Your Honor. Sean Callahan on behalf of the Probation Department.
Yeah, Your Honor.
Sure.
Good morning, Your Honor. Good morning to your staff. May it please this honorable court. My name is Todd Wilson Perkins, P 55623, appearing on behalf of Mr. Smith. And I am, because it's a matter, I believe it's under Hyder, Your Honor, I'm not able to have access to the file. I don't, is this today a show cause date, or I'm not sure what?
I have it down as an arraignment on a violation of probation.
Okay, because it doesn't have, I don't have access to it, other than, I think we had to call your courtroom to get a case number.
All right. Donna, can you make a copy of this, please?
And Your Honor, based upon that, Your Honor, I would ask the court to set aside the warrant. I stand in mute, respectfully ask the court to enter a not guilty plea of this.
Okay. Sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. Please state name for the record and spell it.
Christopher Smith, CHRISTOPHER Smith, SMITH.
Okay. Go ahead, Ms. Callahan, you wanna,
Your Honor, today's the date and time set for Raymond on a probation violation. There are several allegations. The first is that he failed to make payments towards court-ordered costs. The second is he failed to complete flip the script, failed to complete 100 hours of community service work, failed to maintain and find employment, and that he was involved in new criminal activity. There is a pending case in Southfield, Michigan for, it's at actually the Sixth Circuit Court now, for police officer fleeing, CCW, felon in possession of a firearm, malicious destruction of personal property of fire and police, and police officer assault. I believe that matter is scheduled for a pretrial on April 6th.
I believe your probation agent is accurate.
okay,
Information.
all right, I'll enter not guilty pleas on behalf of Mr. Smith. What's the next court date?
April 6th.
April 6th, and that's for,
It's a pretrial. I just got retained, so
I see.
I had no idea. I knew about the criminal issues, which is the reason why I even contacted the court once he told me.
okay,
After he was in the hospital, had a hospital stay, and I just got the discovery in Southfield for Oakland County.
right,
And so that is a pretrial, which I believe it is as serious as those charges are. I believe there'll be some less serious resolution, but I also believe that there's some treatment that goes along with it. I don't want to necessarily, because we haven't gotten that information from the doctor yet.
okay,
So I'd ask the court if the court would track it. He does have retained counsel. I will, I'm expressing to him, and I didn't know what his requirements were or anything, because I would have tried to at least address some of these with his family, some of the outstanding things, particularly the payment. That's something that's a lot easier to do than the things that they're saying didn't do, flip the script and things like that. But I'd ask the court if the court would continue this or track that matter with the Oakland County matter and perhaps come in the day after or.
yeah. Why don't we set this for like, April 14th?
Yeah, on a Friday. Yes.
Yeah. As to bond, Ms. Callahan,
Your Honor, I believe he posted a $25,000 cash bond in Oakland County. I don't have an objection to a personal bond, but I would ask that Mr. Smith report to his probation officer at least twice a month while we're tracking this new case.
and are you working, sir?
He is an entertainer, and we're trying to get him back with the company that he was working with, but some of the gaps that he's had and it's some
Yeah.
medical issues that have,
All right, so I will set a $5,000 personal bond, but put him on a GPS tether. And unless he's working, it's home confinement.
okay.
And then if he gets hours, he can contact the court, we can consider adjusting the hours.
Two things, Your Honor. Would he be allowed to have his family take him to, I don't know where they apply the tethers at, would he be allowed to go and get the tether? And two, would he, because of what he does, as far as that, how would, it's not a set hours, it's not like a job per se.
He's not working at CVS or.
Right, so, that's the difficulty there.
Right, so I guess to the extent he does find work, you can contact the court and we can,
Okay.
Make some changes, but if you're on probation, you're potentially picking up new cases and not working.
Understood.
Now, I mean, Ms. Callahan, if we do an MDOC tether, that'll be a bit easier, won't it?
I can try, Your Honor. I've had some problems with this in the past. I don't think that the county will put a GPS tether on Mr. Smith because he's not in custody right now. I can prepare an amended order indicating that he needs to be on MDOC tether until until his VOP is resolved. I will do my best. That's all I can promise.
Okay. I mean, if I set a bond of 1,000, 10%, does that change anything?
You know, I think he has to go into the jail in order to get a GPS tether. And then they would release him. That's what I'm thinking, because the last that I heard, if you just turn yourself in, that they're gonna turn you away.
Well, I've had people walk over to the jail and get the tethers. I've had that, if they have the order.
All right, well, I'll do MDOC tether at this point.
Okay.
Right.
That means he goes to the probation office.
So he would go, where would he go, Ms. Callahan?
He would report to his probation officer, and I'll prepare the order today. And I'll, send it to you, Judge, to get it signed, and then he'll have to be transferred to the tether unit, which is on Lawton in the city of Detroit. I think Mr. Smith knows where that is. So he just has to report into Mr. Young's, his probation agent.
Okay.
Mr. Perkins, have you had anybody turn themselves into the jail within the last few weeks to get a tether?
Not necessarily, it wasn't the last few weeks, it was maybe in December, or that was, I didn't know if there was some change in the last 2 weeks, if you know something different. I didn't know that, but I was speaking, no, not in the last 2 weeks, agent.
Okay, I mean, things change really quickly and they don't really always tell us what's going on. I'll get the order prepared, Judge.
All right, thank you. All right, anything else, Mr. Perkins?
My client just wanted to let you know that he did flip the script, but every time he's had a miscue, he's had to start over. So he hasn't completed, he acknowledges that, but he also has a fair amount of community service hours. I guess they're just not accounted for in here. I'll do whatever I need to do as his lawyer to bring that to the probation department's attention, and perhaps see an amended order. But
Right, I mean, if they can show proof that he's done the hours, I mean, it's easy to dismiss those things between now and the next time we meet.
I think that, but I expressed to Mr. Smith, the major issue is dealing with Oakland County. So,
I would think so. Yeah, I agree.
so can he wait? And I got another courtroom. Can I wait to get that order and have him wait with me? And so he does, or did you want me to get?
Ms. Callahan, is that going to take you a minute or two, or?
I can probably have it done in 10 or 15 minutes if that's okay.
You want to wait for that period of time? As soon as I get it, I'll sign it.
I'll just have him wait for me, and then I'll get it and give it to him.
Okay, that's fine.
Thank you, Your Honor. Thank you, Agent Evans.
Are you ready?
We are ready, Your Honor. I'm rolling.
Calling case number 23-000-489-01-FH, People of State of Michigan versus Joseph Rowland Jr. Appearances, please.
Good morning, Your Honor. Brett Bailey on behalf of the people, P840009, filling in for APA Jake Bloomers.
And good morning, Your Honor. James Mikowski, P62115, appearing on behalf of Joseph Rowland, saying the right, so can you state your name?
Joseph Rowland. All right. Good morning, Mr. Rowland, Mr. Mikowski, and Ms. Bailey. Move the date set for calendar conference. Mr. Mikowski, do you anticipate filing any motions?
Potentially, yes, Your Honor.
What kind of motions?
I might have to use a 404B motion depending on what the people come. I also, I don't think there'll be a motion to quash, but there might be, I don't know yet what are all motions I might be filing. And we are in talks about a potential resolution. I mean, they're very early talks, but
Talking is good. there been a other acts notice that's filed? It's pretty early.
Your Honor, I'm standing in, I don't believe so. I think this would have been our first date.
Yeah, it's the first date in
Post-opening.
front of me, right, yeah,
Yes.
for sure.
I don't believe there has been yet, Your Honor. I will speak to Mr. Bloomers about the need to file one. But I will ensure that we have it in by Your Honor's deadline.
Let's set this for like maybe April 21st.
April 20, I just checked with Mr. Rollins' calendar because he works every other week, 7 on, 7 off, and I just made sure his calendar was clear. I'm good that too, Judge.
Okay. And that'll be at 8:30 in person.
Will that be another pretrial date, Your Honor?
Yeah, we'll call it a final conference, but if you need extra time, I can give it to you.
Understood, Your Honor. Thank you.
That's April 21st, 9 a.m.
8:30.
8:30. Thank you, Judge. Good to see you as always.
Likewise.
We're both getting a little grayer, aren't we?
Yeah, you know what? Every time I go to the barber, it seems like more gray hair falls out of the floor.
I've had white hair since I was 30, so it's no change for me.
Right. All right, we've got some paperwork for you, so if you just take that before you leave. Have a nice weekend, everyone.
Thank you, Your Honor.
I don't, there's nobody by that. Nope, you are, Callahan is, and Brandon Roy.
Okay.
That's it. Yeah, I mean.
I didn't know if you didn't hear me.
No. So, I mean, I'm looking at my screen to see who's on Zoom, and there's no Collins, no Hodge, no Collins, Hodge.
Thanks, Judge.
Yeah, I don't,
I'll just give it a guy back here.
yeah, I mean, if they were, I should have break our in a second. But they're not here.
Thank you.
Yeah. Do you have any call, Mr.? Have a great day.
Good to see you.
Likewise. Calling case number 22-7778-01-FH, People State of Michigan versus Michael Scott Abraham. Appearances, please.
Good morning, Judge Christopher Quinn, P69483, appearing on behalf of Mr. Abraham.
Oh, we have, this is.
Mr. Molnar only asked me to stand in on Ibrahim Miles.
I think this is gonna be a no-show.
Oh, then I can stand
But
in.
it's
Your Honor.
closed, it's Michael Abraham.
That was so close.
It's
But
close.
yes, Your
I'll
Honor.
talk to him for you, don't worry about it.
Thank you, Your Honor.
The name is
Bryn Bailey on behalf of the people, Your Honor, P84009, standing in for AP of record Andrew Molnar.
This is supposed to be Mr. Abraham's sentencing. It's been on my attention. He was in custody the last time we were here, and I believe he got a fine, then he got, it appears, put back in custody, and then he had to go to the hospital. So somewhere, communication has been lost. I was considering just getting an investigator to try to track him down.
Well, I mean, I think you knew today was the date set for sentencing. He's not here. He's not appeared on Zoom. He's not called. So I'm gonna issue a KPS in order to remand. And he hasn't been interviewed by probation either, so not a good set of circumstances. Have a nice weekend, Mr. Quinn.
You have a nice
Mr. Mr. Holler, are you ready? Are you and Ms. Moses together?
We are, and we are ready.
All right. This is on Greer. Good, Mr. Greer. Calling case number 22-5699-01-FC, People State of Michigan versus Christopher Lewis Greer. Appearances, please.
Judge Erica Moses on behalf of the people, P 78491.
Morning, Your Honor. John J. Holler, appearing on behalf of Mr. Christopher Greer. Mr. Greer, can you stand up briefly, please, sir? My bar number is 43344.
Yes, sir. Please take your name.
Christopher Greer.
Good morning, Mr. Greer, Mr. Holler, and Ms. Moses. Go ahead, Mr. Holler.
Judge, we're here today just to monitor the prosecution's production and turnover of a toxicity report for two decedent victims in this case, Dominic Parchman and Cheyenne Hall, that hadn't been conducted by the medical examiner in this case. They haven't been produced yet. I believe that Ms. Moses is working on that, and she can speak for herself as to where she is.
Judge, I did contact OIC shortly after the last hearing that Trish Gerard stood in for me. He did not provide me with any toxicology reports, but I have contacted Victor Jernigan from the medical examiner's office, administering that he would send me any reports associated with the medical examination report in regards to toxicity of the two decedents. I hopefully have that by end of day today. I'll send that to Mr. Holler. I am meeting with the OIC next week to make sure I have everything that he has, and we should be trial ready, Judge. And I do have an offer at this time, if Mr. Holler would want that on the record.
Sure.
The offer is for Mr. Greer to plead to one added count of murder in the second degree and count 4 felony firearm. The years would be 50 to 100 plus 2 for the felony firearm. There is room for negotiation if Mr. Holler would like to contact myself or my supervisor, LaDonna Logan. She will be remaining on this case with me.
Okay, the offer is acknowledged. Thank you, and I will certainly be in touch. And what I'd like to do, Judge, in order to monitor the turnover and the production and turnover of the toxicity report in both cases, I think it would be wise for us to have another follow-up date, maybe April 7th, I'm suggesting.
How soon do you think you'll have that toxicity report? Pretty soon, right?
I'm hoping to have it by end of day is what I was told, but worst case scenario, I think by sometime next week, early next week. So I'm fine with the April.
How about the 6th?
That's fine.
We could do April 6th.
Okay. See you on April 6th.
Judge, we do that at 8:30. I have a trial.
8:30 is great. I'm here at 8:30.
Okay, great.
All right, thanks, everyone. Have a nice weekend.
I'm ready on. So, but I'm gonna go see if this girl is on Zoom. There's a girl named,
If you're ready, I'm sorry.
Antonio O'Brien, she's a prisoner violator.
Oh.
He's
Donna,
back
do
there.
you have that file now? Antonio Bryant?
Most probably not.
You have a case number?
Oh, yes, it is 20 001681.
001681.
He's the first, he's the only defendant on it. Well,
What's the name?
let me, 01 FH.
What's the name?
Antonio Bryant.
Thank you.
All right,
I was
thanks.
gonna ask if Tamika.
Right here. Even
Oh.
better.
Pretty good. How are you there? You remind, okay, you get the same name as your. Okay, just a second. Molnar funeral home, yes. I do remember that, that you told me that, some of the story of your wife. And said last that she was going to have more relationships for the year. And then you started with said, yeah, right, famous last words. Yeah, basically right. It's only when you're not. Yes, that stuff would, maybe that's more important. What's your name, sir? Right. Right. What was the professor?
Oh,
Just
okay.
sort of out in that class by asking for the-
Yeah, it was like icebreakers.
Right.
Actually, we.
Where'd you go to school?
Michigan. She works. NCAA tournament on Saturday.
You know, I have a group of friends, I used to practice in bankruptcy a lot of years ago. And I have a group of friends from those days and we always get together for March Madness and watch like the first round. And I only see them once a year.
Yeah.
And so yesterday we were gonna get together. But every year we get together at some place like Wild Wings or some other sports bar, you know, sort of. Show up, watch a game. Every game we've ever watched together, Michigan won every one, so we got a good winning streak. So, but I didn't do it this year.
Yeah, I get that. All my good friends are so pro.
Yeah. Where'd you go to law school?
University of Florida.
Florida. You are a Wolverine and a Gator. I'm a Wolverine and a Husker. Pardon me? Yeah.
Out of state.
Why would you be glad you left Florida to come back here in the sleet and snow where everybody really does want to be?
The weather sucks.
The weather sucks. We're here.
Yeah.
Like what?
I mean, you know, I live in Gainesville.
Yeah. Florida's in three parts. You got Miami, you got Central Florida, and you got Dixie, Florida.
Yeah, so it's a lot of that. My parents live in Marco Island. So they live in South Florida.
You're a Yankee. You were in foreign territory down there with all those residents. No, I feel right at home. It was fun.
Country music. So, so nice.
Yeah, the Yankees can't stand all that nice and hospitality and stuff like that. That's a purple lemon Skinner. Isn't it?
Yeah.
They come from Gainesville?
Yeah, Gainesville and,
Yeah, I think last week, the last original band, Skinner passed away.
Yeah.
Yeah, I know, that's the thing. Soaking wet.
I remember.
For a good reason.
Yeah, it's.
I can't believe the day game. Got back and forth. You know,
We do, Ms. Vanderino.
Good
Louisiana
morning.
State, they always play on the phone like that.
I am in search of Michael Hampton.
Oh.
Do we know where he is
I
hiding?
think he may be in G2.
And I remember one day down there.
But I could be wrong.
100 degrees.
No, he is truly the circuit court judge. He travels from courtroom to courtroom.
So, does he have his own diner? Or is he shadow?
I think he's taking a lot of space. So I think he could be, you might want to check Judge McCarthy's courtroom. He may be there, but I'm not sure.
Good morning. According to the calendar, he's in 601 today.
Oh.
Who's
I'm
in
in
601?
Knapp, just one for.
Judge Hathaway today. As a visiting judge.
Oh, really? Oh, I popped in there earlier. I didn't see you.
I could be wrong. Maybe the calendar's wrong.
I'll check my notes. I appreciate it.
Yep.
Well, 601 would be Judge Edwards.
Prentice was at 8.
Oh, that's right. Okay.
Like,
I know. That's why I had David. He's in charge.
And he even hears and appears when you need him.
Yes.
When I'm ready, I'm the Nathan Monroe who's here.
Okay.
I'm ready, and Antonio. What's his name?
Brian?
Brian also. Hello, Judge, what's her name is calling me. She told me to be there at 10 and I was, but she had a courtroom where people doing a sentencing, so they just called me. I told her I'm here first.
Okay.
I
So,
know
all
this court is efficient.
right, we'll do Monroe.
Thank you, Judge. Hey, violators.
Calling case number 16-000423-01-FH, People of State of Michigan versus Tamika Monroe. Appearances, please.
Good morning, Your Honor. Sean Callahan on behalf of the Probation Department.
Good morning, Your Honor. Wendy Barnwell on behalf of Ms. Monroe, who's present here in court.
Sir, ma'am, please state your name.
Tamika Monroe.
All right, good morning, Ms. Monroe, Ms. Barnwell, and Ms. Callahan. Go ahead, Ms. Callahan.
Your Honor, today's the date and time set for arraignment on a violation of, arraignment on a show cause that alleges that Ms. Monroe has not paid restitution. She has not paid court costs in the amount of $1,666.50. And she has several outstanding warrants for her arrest that she has failed to clear up in a timely manner.
Ms. Barnwell?
Your Honor, I respectfully ask, to enter a plea of not guilty on her behalf. Now, I want to explain what's going on.
All right, ma'am, can you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? All right, please state your name for the record and spell it.
Tamika Monroe, Tamika Monroe, Monroe.
Okay, and you read, write, and understand the English language?
Yes, I do.
All right, you understand all the allegations against you?
Yes, I do.
All right, I'll enter not guilty, please, on behalf of Ms. Monroe. Go ahead, Ms.
Your Honor, she has a daughter who just had major surgery. She's been having a rough time financially. She has been also terrorized by her ex, who is on probation on paper to her address. He's on probation at 36th district. She has all kinds of marks on her. She's traumatized. She doesn't have the money, but she indicates that she can pay $100 on the purse.
Well, I have no idea or no objection to 100 hours of community service in lieu of court costs. I want to do that too.
In lieu of court costs, that means in place substitute. Get it? He's just telling you that now. He's ordering that.
So, thoughts, Ms. Callahan?
Your Honor, I apologize. I couldn't hear what the defendant or Ms. Barnwell, I didn't hear what they said.
I don't think they really said anything. They were just referring between themselves, I think.
Okay,
I guess if she's having trouble paying court costs, I have no problem with 100 hours of community service instead of court costs. How quickly can we get these outstanding warrants resolved? This is a 16 case and
Your Honor, she thought she had a lawyer taking care of this, who was court appointed. I told her the system, the way how it works is, I don't think a lawyer is gonna do all these jurisdictions. I know how it works. So I'm advising her first to appear, call the court. 36 has lawyers that will do this. You don't pay them. But you gotta get a court date on each case. So she just needs a copy of this so she can see. So I'll give her a will. Mine has a bunch of notes, but I think realistically, Your Honor, they don't want, you not walking it under it. No, they're not.
Judge, could I suggest to the court that we adjourn this for 60 days? This is a very old case. And allow Ms. Monroe some time to do her community service work and maybe clean up those warrants?
right, and I guess this is the other thing too. There's probably some late fees, I would imagine, in all this. So, if you could focus on the restitution, get that paid off, and I can look at maybe waiving some late fees if there are any. Right, but you got to focus on the restitution. This is an old case. All right, so let's set this for, well, May 19th.
That's good for probation.
Good judge, is that like a review date?
Yes.
Okay.
So well, maybe like continued show cause hearing. How about that?
Oh, okay. And Your Honor, she has to come in here physically or can
Yeah.
she Zoom?
No. Come
I
in
didn't hear
person.
you.
In person,
Physical?
please.
Okay.
All right. But you get focus on the restitution, getting that. Are you working?
No, I'm supposed to start working next week. I had to flip off because I don't want to know where I'm working. That's last time I just had. I got fired because it came to the job and nothing back in my head. The things got messed up. I got fired.
I'm telling her she has to call probation at 36 to complain. He's supposedly on probation at 36. Listen, not calling your probation officer. She's not a police officer. She's not going after him. It's his probation. You start at 36 district. That's how that works.
Okay. All right. Good luck to you. See you on the 19th.
Thank you,
May.
Judge.
Thank you.
All right, wait for me. I gotta get you a copy of this.
Okay.
Please see the case numbers.
Question.
Yeah.
Is Michael Hackley?
You're the second person asking.
Is Marino the other person?
Yes. I think he's at 601. That's the best information we have.
I guess he wasn't there, Judge.
Oh, he's not?
Maybe
Hold
just
on.
G2.
I have an idea. Okay. Calling case number 21-8088 -01-FH, People State of Michigan versus Lorraine Hodge. Appearances, please.
Good morning, Your Honor. Sean Callahan on behalf of the Probation Department.
Good morning, Your Honor. Wendy Barnwell, P 42505, on behalf of Mr. Lorraine Perry, Collins Hodge, and we are both together here in court.
Sir, please take the name.
Good morning, Lorraine Collins Hodge.
Good morning, Mr. Collins Hodge, Ms. Barnwell, and Ms. Callahan. Go ahead, Ms. Callahan.
Your Honor, today's the date and time set for arraignment on a show cause violation that alleges that Mr. Collins Hodge failed to obtain a GED, failed to complete 100 hours of community service work in lieu of court costs, and failed to make payments towards court-ordered assessments.
Your Honor, we are asking the court to enter a plea of not guilty on his behalf.
All right, do you understand? Please raise your right hand. You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. All right, please state your name for the record and spell it.
Lorraine Collins Hodge, LARAYCOLLINS
Okay. And you read, write, and understand the English language? You understand the allegations against you?
Yes, sir.
All right, I'll enter that guilty pleas on behalf of Mr. Hodge. How do you want to proceed, Ms. Barnwell?
He wants to be able to complete these things. He indicates that he's working on his GED. He
How many hours of community service have you completed? So you haven't paid or you haven't done community service. You gotta pick one or the other. So. Are you working?
Yes.
Where do you work?
Doing codes and Romans is connected to the airport.
I'm sorry?
Doing codes and Romans is connected to the airport.
How many hours do you work?
40 hours.
Well, you gotta get that GED. I honestly care more about that than I do the court costs and the fees.
I took my test. I just gotta go back to my classes.
Right? All right. Thoughts, Ms. Callahan?
Your Honor, could we adjourn the show cause 30 days and Mr. Hodge could come back and show verification of enrollment, some community service work, or some payments?
All right. We'll set this for April 21st. Right? You need to make a good effort at this, otherwise, right? And it's, you don't want further sanctions. This is all stuff you can do. If you're working, you can start making payments towards your costs and fees, or if you want to, do community service, talk to your probation agent and figure it out. But you got to start. All right? We'll see you on April 21st. Have a good weekend.
And then there's Antonio in the back, Judge.
Mr. Bryant?
Yes.
Okay, can Mr. Bryant, please? Buenos dias. You're on, Ryan James.
Miss James is out in the hall. Brown's mine. Her client's downstairs. Bella went back upstairs.
Who's the co-defendant?
My client's Brown. He's the co-defendant. I forget who Miss James's client's name is.
I've got you down as Dorian James, no?
Oh, Dorian James. Yeah, yes, Dorian James. I get confused, Your Honor, because Nicole James is the attorney on the other co-defendant, and too many people named James. I apologize. And I have a bunch of matters set this morning, so. I'm here. I'll be back when I'm summoned. Ms. James will text me.
Calling case number 20-1681-01-FH, People State of Michigan versus Antonio Dominic Bryant. Appearances, please.
Good morning, Your Honor. Sean Callahan on behalf of the Probation Department.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Antonio Bryant. We're both present in court.
Yes, sir. Please state your name.
Antonio Bryant.
Good morning, Mr. Bryant, Ms. Barnwell, and Ms. Callahan. Go ahead, Ms. Callahan.
Your Honor, today's the date and time set for arraignment on a probation violation that alleges that Mr. Bryant absconded from probation supervision, failing to be available for his scheduled report on 9/21/21, having last contacted the probation department by telephone on August 17th, 2021.
Your Honor, I've advised my client of the allegations in the petition. I've advised him of the preponderance of the evidence standard to be met at a probation violation hearing. He wishes to waive the hearing and to enter a plea of guilty with an explanation.
All right, sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Please state your name for the record and spell it.
My name is Antonio Bryant. Antonio is Antonio, Bryant, Bryant.
Can you read, write, and understand the English language?
Yes, sir.
All right, how old are you, sir?
I'm 34.
And how far have you gone in school?
To medical school. I got out of high school. I didn't finish medical school.
All right. Did you finish college?
No.
You're charged with violating the terms and conditions of your probation. You're on probation for carrying a concealed weapon, which carries a statutory maximum penalty of 5 years. Do you understand that?
Yeah.
Under Michigan law, you have the right to a contested hearing. You can challenge the probation department's claim that you violated your probation. At that hearing, the probation department have to prove to me it's more likely than not that you violated your probation. Do you understand that?
Yes, sir.
And you want to give up your right to a contested hearing and instead plead guilty to the alleged probation violation.
Sorry.
You want to give up your right to a hearing and instead plead guilty to the alleged probation violation.
And with the hearing.
Well, at a hearing, you'd have the probation department would have to prove to me by a preponderance of the evidence.
Oh, okay. Then,
All right. Has anyone threatened you, coerced you in any way, forced you to plead guilty?
No.
Has anyone promised you anything so you plead guilty?
No.
And is it true that you absconded from probation and your last contact with probation was August 17th of 2021?
That was the part where there's confusion. Because it was a long, drawn out time that I was calling and I wasn't getting no answer. I even had to call my previous court-appointed lawyer, Mr. DiMaggio, who I'm still in contact with, to actually get my first probation officer changed because there was no contact between me and him at all. And the first time that happened, he violated me because he didn't answer the phone when I called him. So I called Mr. DiMaggio to get my probation officer switched because I felt like I was being poorly represented by
when was your last contact with probation? When was the last time you contacted probation?
I thought it was 2019, so it had to be 2021. I just thought it was 2019, so it probably was 2021. The month and day, I'm not sure.
Okay, so the last time you had any contact with probation was 2021?
Yes.
All right, I'll accept it. Ms. Callahan?
Your Honor, given the fact that Mr. Bryant's been gone for about a year and a half, I know he doesn't have any new criminal cases, but I'm going to ask the court to extend probation for 1 year with 45 days MDOC tether, and we would submit an early discharge if all other conditions have been met prior to that 1 year.
Ms. Barnwell?
I just want you to know, Judge, that I just want to know that he works at Chrysler. So I know tether usually has restrictions on hours. He's a high-low driver at Chrysler. He's been working there for about a year now.
Yep, a little over.
He had applied at a hiring event. And he got licensed there for high-low. He took training there for high-low driver. And things are pulling together now for him. I
What are your
also
hours,
remember,
sir?
pardon?
What are your hours?
I work from 6 a.m. to 3:30 p.m. 5 days a week. Sometimes we get Saturday, same hours.
Okay.
So Maxine, if you don't put on the tether, I know that it's easier to get in contact with people now than when we were in the midst of the pandemic. You couldn't reach by phone and all that. Once you were not in the rhythm of contacting somebody through emailing or something electronic, it was not possible. I mean, people weren't in the building, so I comprehend that. So I know that's some sort of a punishment, and I understand
So
that
how
that's
about if
way
I
better
set
than
the,
being in
how
jail.
about if I set the tether hours? He has to be at home from midnight to 5 a.m.
To 5 a.m.?
Yeah.
Okay, you had that, Mr.
Yes, definitely.
Because that's normal for everybody almost, okay? And that's for the 45 days, right, Judge?
Right. All right, I'll accept the, anything you want to say, Mr. Bryant?
I do apologize for the violation. It wasn't anything that was malicious or anything like that. It was just the confusion of what was going on during the pandemic. It was really hard to get in contact with them. I mean, I was called. I even took it upon myself to get my probation officer changed so I could do the probation.
Okay, well, we're past that
So
now.
much confusion.
All right,
We're past that,
So
but we
I'll
just
adopt the
moving forward.
I'll adopt the recommendation, 45 days on MDOC tether. Needs to be home from midnight to 5 a.m.
Your Honor, could I get an updated address and phone number?
So what's your address?
It's 12763 Flanders. And my phone number, my direct number.
What city is that?
Detroit, Michigan.
And your phone number?
It's 313-492-0499.
Did you get that, Ms.
I'm-
Callahan?
I did not. I got 12763. Was it Flanders?
Flanders in Detroit.
Okay, and your phone, sir?
313-492-0499.
Thank you.
Well,
All right, thank you, everyone. Have a nice day.
Probation extended to 1 year.
Yeah, I'm sorry, probation is extended 1 year.
so I'm sorry, what's the forward?
Be a year from today, be off.
Okay, thank you.
The tether is only for 45 days, don't violate it. They'll bring you back here in a heartbeat.
Thanks.
You have everything from me, right, Madam Clerk? Thank you. Have a good day, everybody.
You too.
Judge, are we still waiting for Mr. Roy or did that get moved?
So apparently he's on his way. He was on Zoom earlier and he's on his way. And I told that his attorney, Ms. Watt, is also on her way.
Oh, okay. I'll sit tight. Thank you.
All right.
Apparently Miss Mitchell is coming back,
Yeah.
so she's in Regina Thomas. So. I told him that getting her over here helps him get to watch the game. Because as soon as I'm done here, I can go there and stand in for him.
Yes. Calling case number 23-000064-01-FH, People State of Michigan versus Ibrahim Miles. Appearances, please.
Andrew Molnar on behalf of the people.
Good morning, Mayor. Please, this most honorable court, read a list of appearing on behalf of Mr. Ibrahim Miles. Mr. Miles, state your name for the record.
Good morning again, Mr. Miles, Ms. Mitchell, and Mr. Molnar. So it looks like we have a resolution. Mr. Molnar, would you please place that on the record?
Yes, Judge. Mr. Miles will plead to count one, operating while intoxicated. Third offense notice, which is a statutory maximum penalty of 5 years. The people would agree to dismiss counts 2 and 3. There would be a sentence agreement of 2 years probation, first 30 days Wayne County Jail, substance abuse assessment and treatment as recommended, and any other terms and conditions set by the court.
That's full and accurate understanding, Ms. Mitchell?
Yes, it is, Your Honor.
All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? All right, please state your name for the record and spell it.
Ibrahim Miles, Ibrahim Miles.
All right, do you read, write, and understand the English language? All right, you'll be asked a series of questions. If at some point you can't hear, you don't understand something someone says, please interrupt and let us know. And then we'll stop and go over it again to make sure that you do hear and you do understand, okay? And if you're asked a question, you give an answer, I'm going to assume that you understood the question. And the answer that you gave was the answer you intended to give, fair enough?
Yeah.
All right, have you heard and understood everything so far? All right, how old are you, sir?
46.
And how far have you gone in school?
College.
Are you a United States citizen?
Yes.
I'm holding in my left hand a form entitled Settlement Offer Advice and Rights Notice of Acceptance. And it contains the plea and sentence agreement that was just placed on the record. Have you seen this form before?
Yeah.
And did you review this form and its contents fully with your attorney, Ms. Mitchell?
Yes.
Did she explain the plea and sentence agreement to you?
Yes.
Did she answer all of your questions? Did she explain to you the rights that you're giving up by pleading guilty? And did you sign this form?
Yeah.
Did anybody force you to do that? And did anybody promise you anything other than that which is contained in this form?
No.
You understand with this plea, you face a statutory maximum penalty of 5 years in prison.
Okay.
And you understand if you proceeded to trial and you were found guilty as charged, you'd face a statutory maximum penalty of 5 years in prison. And are you satisfied with Ms. Mitchell's representation of you?
Yes.
You understand you have the right to a jury trial, which 12 impartial jurors would decide whether you're guilty or not guilty of any crime charged.
Yes.
You understand you can give up your right to a jury trial and allow me to sit as the fact finder to determine whether you're guilty or not guilty of any crime charged. You understand you have the right to be presumed innocent until proven guilty. You understand you have the right to have the prosecutor prove your guilt beyond a reasonable doubt. You understand you have the right to have witnesses against you appear in trial to testify. You understand you have the right to question and cross-examine those witnesses through your attorney, Ms. Mitchell. You understand you have the right to call your own witnesses to court. You understand you have the right to have the court subpoena or summon witnesses on your behalf, requiring them to appear. You understand you have the right to remain silent at a trial, and you cannot be compelled to testify. You understand you have the right to not have that silence used against you. So in other words, if you decided to proceed a trial and not testify, I would instruct the jury that they couldn't hold that silence against you. You understand you have the right to testify on your own behalf, if you so choose, at a trial and tell your version of the facts. I can hardly hear you.
Yes.
Okay. And you understand that by pleading guilty, you're giving up all the rights that we've just reviewed.
Yes.
Other than the plea agreement and sentencing agreement that were placed on the record, does anyone promise you anything so you plead guilty?
No.
Has anyone threatened you, coerced you, in any way forced you to plead guilty?
No.
You understand that if I accept your plea, you'll be giving up any claim that your plea was the result of a promise or a threat, unless you tell me about it right now. Are you pleading guilty voluntarily and of your own free will?
Yes.
Are you currently on probation or parole?
No.
You understand that by pleading guilty, that you're giving up your right to appeal your guilty plea as of right, and even though the Court of Appeals may grant you leave to appeal, it's by no means obligated to do so. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. All right, and to Ms. Mitchell and Mr. Molnar, either be aware of any promises, threats, or inducements other than those already disclosed on the record.
No, Your Honor.
All right, Mr. Molnar, would you please create a factual basis?
I guess the only promise was that we did tell him that we wouldn't object to a later sentencing date.
Right, I indicated that I would set sentencing until June, when there's kids get out of school.
The end of June, like mid-18th, 19th. I'll ask you probably July, beginning of July.
Well, I'm not gonna wait till July.
The end of June.
So, I mean, typically,
'Cause I gotta
kids are
make
out of
sure
school
that-
like mid-June, so.
Yeah, I gotta make sure that they got a ride, 'cause I'm gonna have to take them out of state.
So we'll say like right now, June 16th.
That's when they get
Your
out.
Honor, can we do it like the next week? Cause I think my daughter is at DPS and I think it's that week that they are out. I'm not sure the exact date, but that next week, the 20th or something should be better. I know for a fact that.
All right, we'll set up for the 20th.
Hey, Judge, can I, no other promises, anything, can I create a factual base?
Please.
Okay. Mr. Miles, on July 22nd, 2022, were you present at Sibley Road near Middle Belt Road? Is that in Huron Township, Michigan, County of Wayne?
Yeah.
Okay, and on that day, at any point, were you operating a vehicle? And was that vehicle approached by the police? Okay, and when that vehicle was approached by the police, were you under the influence of alcohol? Okay, and in fact, you later found out that your blood alcohol content was above the legal limit, correct?
00.9.
Yes.
110.
Is it also true that on January 3rd, 2019, in the 33rd District Court in Woodhaven, Michigan, you were convicted of operating impaired?
Yes.
Okay, and is it also true that in September 10th, 2019, in the 23rd District Court in Taylor, Michigan, you were convicted of operating impaired?
Yes.
Okay, the people are satisfied with it.
Satisfied, Your Honor.
All right, have to comply with Court Rule 6.302.
Yes,
Your Honor.
All right, I find that Mr. Miles' plea is understanding voluntary NACA, and I'll accept his guilty plea. He'll be referred to the probation department for a pre-sentence investigation report. We'll set a sentencing date of June 20th. All right, so Mr. Miles, and I'm gonna require a scram tether, an alcohol tether as a condition of bond. And there's to be no drinking while you're on bond. And so you have to go to the probation department for a pre-sentence investigation report interview. So when you leave here, come out of the building. Do you know where probation
Yeah,
is?
by the blue building.
Right over by the Harbor House Restaurant. All right, so just go there, set up an appointment for a pre-sentence investigation report interview, okay?
Thank you.
Thanks, have a good weekend. Thank you. But where's? All right, I guess we'll wait for Mr. Miller.
I haven't heard from Mr. Miller this
He
morning.
was in earlier, but nobody else was.
Sorry, Judge, I know everybody's running to different courtrooms.
All right, well, I guess we can do Mr. James.
Mr. Robinson.
Oh, this is Mr. Robinson?
This is Robinson.
Oh, that's right. We got James for Robinson and then Miller for James.
Correct. This is your honor.
We're also ready on our Roy.
basically. Yeah. Are they good?
Is, is Blake getting, Corey James? Okay. From down in detail. Oh, I see. I see, okay. What's that? Okay. You want to do Mr. Roy while?
Yeah.
Oh.
But you can go ahead, because I can go.
Calling case number 21-6697-01-FH, case number 22-7681-01-FH. People state of Michigan versus Brandon Roy. Appearances, please.
Andrew Mulder on behalf of the people.
Good morning, Your Honor. Coral Watt appearing on behalf of Brandon Roy, 41508.
Sir, please take me.
Brandon Roy.
SWAT is Mr. Mulder. Where we at, Ms. Watt?
Your Honor, we reviewed the pre-sentence report. It is, we do have one correction to the briefing. We did want to make the court aware there are a number of outstanding misdemeanor and traffic warrants and tickets. So we want to let the court know that all of those tickets have been taken care of. By taking care of, Mr. Roy did a plea by mail while in custody. He was in custody for 4 months. And so that took care of most of the tickets. The ones that are remaining are a no insurance out of Huron Township, a no insurance out of Trenton, and 10 traffic tickets out of the city of Detroit, which he is in the process of setting court dates for and taking care of. And he said on the tickets that he took care of with the plea by mail, the only thing remaining is he has to pay, I think, a $45 reinstatement fee.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you?
Yes, I do.
All right, please state your name for the record and spell it.
Brandon Roy, BRANDONROY.
Put your hand down. Do you read, write, and understand the English language?
Yes, sir.
If you had a chance to review the pre-sentence investigation report, and sentencing guidelines with Ms. Watt,
Yes, I have.
do you have any changes, additions, or deletions to the pre-sentence investigation report?
No, sir.
You find it to be factually accurate?
Yep.
And any issue with the, you have any issue with the way the sentencing guidelines are calculated? No. Do you have any issue with the way the sentencing guidelines are calculated this one?
No, Your Honor, and he's saying he has no issue. We're just correcting because in the body of the report, it indicates that all of these tickets are still outstanding, and we just wanted to make the court aware that that's incorrect.
So, I'm sorry, which tickets were?
It's probably easier to tell you the ones that have not been handled. Because there's so many of them. The ones that had, there's Huron Township.
Hold on for 1 second. So, all right, go ahead.
Okay, so Huron Township, no insurance has not been handled yet.
That's the first, wait. That's 11,
Yes,
has not been hit,
has not been handled yet.
okay?
Trenton, no insurance has not been handled yet. 14, yes. And then all of the traffic tickets out of the city of Detroit have not been handled yet because those have actual court dates.
So that's 1, 2, 3, 4, 5. Right?
Yes,
Okay,
the remainder of the tickets have been handled. They are remaining in warrant status until he pays that $45 reinstatement fee. But they've been handled in terms of they accepted his plea by mail. And also, he said he went to court for some of them while incarcerated during the 4-month period.
Just was unaware about the clearance fees. So when when I got the paperwork back, I thought it was all just said and done. I didn't know that.
And so he anticipates on paying off those clearance fees. How long will that take?
As soon as possible, a few months. I'm hoping it doesn't even take that long. That was the point of me turning myself in August to Oakland County, is because I just got sick of running and I just racked all these up while I was young and being irresponsible. I've never been away from my family and kids for longer than 30 days, so it's just a big eye opener for me.
okay. Any other changes?
No other changes, Your Honor.
And you said there's no issue with the,
The guidelines, that's correct. We're just asking the court to impose a sentence agreement appropriate.
and Mr. Molnar, any issue with the pre-sentence investigation report on sentencing guidelines?
No, Judge.
Or anything you want to say, Mr. Roy?
A big lesson learned for me. Spent the last 10 years of my life, getting in trouble with the traffic stuff and back and forth with, abusing prescription drugs. Usually just brushed it off and didn't care. I do now. hoping that, you know, the work I put in by turning myself in and trying to stay on the right track, you know, shows for something. I'm ashamed, very ashamed. It's embarrassing to stand up here with, you know, 21 traffic convictions. Just embarrassed, and I'm sorry. I'm trying to be accountable now. I know I haven't in the past.
All right. Anything else, Mr. Mulder or Ms. Watt?
No, Your Honor.
No, Your Honor.
All right, with that, it's sent to the court that Mr. Roy be placed on probation for 2 years, subject to the following special conditions. Use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment in a specific location. You must comply with the requirements of alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent and adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. You must comply with the requirements of drug testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician to be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by a licensed physician. You must attend AA, NA, and/or CA meetings at the frequency required by the field agent. You must complete outpatient or residential substance abuse treatment when you're referred by the field agent. You must complete a substance abuse assessment when you're referred by the field agent. You must participate in an adult education or GED program as directed by the field agent and complete it. You must complete a psychological evaluation when you're referred by the field agent. You must obey all court orders. You must not engage in any assaults of abusive, threatening, or intimidating behavior. You must not have verbal, written, electronic, or physical contact without the permission of the field agent with anyone you know to have a felony record. You must not have verbal, written, electronic, or physical contact with anyone you know to be engaged in any behavior that constitutes a violation of any criminal law of any unit of government. You must not change residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must not own, use, or have in your control area control a weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know to possess these items. You must contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer without need of a warrant if the field agent has reasonable cause to believe you violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must make genuine efforts to find and maintain legitimate employment of a minimum of 40 hours per week, unless you're engaged in an alternative program. You must provide ongoing verification of employment alternative program to the field agent. You shall not give reason to be terminated or voluntarily terminate your employment alternative program unless you first obtain written permission from the field agent. You're to pay $68 state costs, a crime victims assessment, the amount of $130 pursuant to MCL 791.225A. You must pay a supervision fee of $30 per month for each month of regular supervision or $60 per month for each month of electronic monitoring supervision. You're going to pay court costs in the amount of $1,300. The state court administrator's office has determined that $1,300 is the average cost of this court in the case that proceeds through it. And it covers salaries and benefits for court personnel, goods and services necessary for the operation of the court, and necessary expenses for the operation and maintenance of court buildings and facilities. And you may perform $100 hours of community service in lieu of court costs. Ms. Watt, how long have you practiced criminal law?
Over 25.
And how many hours have you put into this case?
Probably about 10.
And if you were retained, what would your hourly rate be?
$250.
All right, understanding Ms. Watt's education, training, and experience, level of effort she's put in this case, and even if I dramatically cut her hourly rate, $400 would still be a bargain, so we're at $400 in attorney's fees. And there's to be no driving without a valid license. terms of rehabilitation goals, they are refraining from the use of illicit narcotics, refraining from the use of alcohol, obtaining additional education, so you have more career opportunities, obtaining legitimate full-time employment so you can support yourself, and obtaining any other necessary treatment. Mr. Roy, it's my duty to advise you have the right to request leave to appeal from the Court of Appeals. For anyone to afford an attorney to prepare post-conviction motions or perfect an appeal, this court will appoint an attorney for your public expense. We will provide that attorney with such portions of the transcript as that attorney may require to prepare post-conviction motions or perfect an appeal. You're further advised if you wish to file an appeal or motion, the request for the appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days of today's date. Mr. Roy, do you understand your appellate rights?
Yes, I do.
Do you have any questions about your appellate rights?
No, sir.
They've been placed on probation and as such you may be eligible for early discharge after you finish one half of your term of probation and if you've completed all required programming. If you complete all required programming, the probation department may notify the court of your eligibility for early discharge from probation. The probation department does not notify the court of your eligibility for early discharge from probation. You've not violated probation in the previous 3 months. You may notify the court of your eligibility for early discharge. They'll give you some information in writing regarding eligibility for early discharge. Do you have that?
Yes, I do.
Okay. Anything else on that front? This one,
Nothing further.
Ms. Rulner,
No.
Ms. Callahan?
Sean Callahan on behalf of the probation department. Your Honor, with regards to the probation violation under docket number 21-6697, I would ask the court to continue probation to term, which is until February 17th, 2024, with all previous conditions to remain in effect.
So understanding that he's pleaded guilty, been sentenced in case number 22-7681-01-FH. Obviously, that constitutes a violation of probation. Case number 21-6697-01-FH. Any objection to the sentencing recommendation from the probation department, Ms. Wong?
No, just one question, Your Honor. So he will be reporting to the same probation officer for both cases, correct?
Is that right, Ms. Callahan?
Yes, he'll have the same probation agent for both cases.
Okay, then no objection.
All right. Anything you want to say, Mr. Roy, on that front?
No, Your Honor.
All right, I'll adopt that recommendation. All right. Have a nice weekend. Good luck.
And Your Honor, his tether.
Thank you.
Sure, I'll remove his tether. Is that just a GPS tether, right?
Yeah.
All right, I'll remove the tether.
Thank you.
sir.
Calling case number 22-7861-1-FH, information regarding this document be found in case number 21-6697-01-FH. Are we ready for Mr. James?
Mr. Robinson.
Oh, I'm sorry, gosh, I'm sorry.
Have a good weekend, Judge.
You too. Calling case number 21-3432-01-FC, People of State of Michigan versus Tyson Robinson. Appearances, please.
Good afternoon, Your Honor. John Bell on behalf of the people, P68673.
And good afternoon, Your Honor, Nicole James, appearing on behalf of Tyson Robinson. My P number is 58961.
Yes, sir, please take your name.
Tyson Robinson.
Good afternoon, Mr. Robinson, Ms. James, and Mr. Vella. So it looks like we have a resolution. Mr. Vella, would you please place that on the record?
Yes, Your Honor. Your Honor, the defendant pleads guilty to count 2, which is felony firearm under PAC code 750.227B-A, which requires a 2-year prison term consecutive with and preceding the added count 3, which is murder in the 2nd degree under PAC code 750.317, maximum penalty of life. The people would enter into a sentence agreement with those 2 counts, whereby he will serve the 2 years on the felony firearm, preceding and consecutive to 15 to 30 years on 2nd degree murder, and that will also be requiring restitution in any terms and conditions ordered by the court. In turn for that plea, we would dismiss count 1, murder in the first degree.
Full of understanding, Ms. James?
Yes, Your
All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell it.
Tyson Robinson, TYSON, ROBINSON.
All right, you read, write, and understand the English language?
Yes.
All right, sir, you'll be asked a series of questions. If at some point you can't hear or you don't understand something someone says, please interrupt and let us know. Then we'll stop and go over it again to make sure that you do hear and you do understand, okay? I can't hear you.
Yes.
All right, if you're asked a question and you give an answer, I'm going to assume that you understood the question and the answer that you gave was the answer you intended to get. Fair enough?
Yes.
All right, have you heard and understood everything so far?
Yes.
All right, how old are you, sir? And how far have you gone in school?
12th grade education.
Are you a United States citizen?
Yes.
I'm holding in my left hand a form entitled Settlement Offer Advice and Rights Notice of Acceptance, and it contains the plea and sentence agreement that was just placed on the record. Have you seen this form before?
Yes.
And did you review this form and its contents fully with your attorney, Ms. James?
Yes.
Did she explain the plea and sentence agreement to you?
Yes.
Did she answer all of your questions?
Yes.
And did she explain to you the rights that you're giving up by pleading guilty?
Yes.
And did you sign this form?
Yes.
Anybody force you to do that?
No.
And did anybody promise you anything other than that which is contained in this form?
No.
Do you understand with this plea, you face a statutory maximum penalty of what, 32 years in prison?
Yes, Your Honor.
You understand that? And you understand second degree murder carries a statutory maximum penalty of life in prison. And you understand if you proceeded to trial and you were found guilty as charged, you face a mandatory life in prison without the opportunity for parole.
Yes.
And you understand that with the felony firearm count, in this case, you'll have to serve 2 years on the felony firearm before you begin your sentence on the second degree murder.
Yes.
You understand if you're convicted of felony firearm with a premeditated murder, you have to serve that 2 years before you begin your life without parole sentence.
Yes.
Are you satisfied with your attorney's representation?
Yes.
You understand you have the right to a jury trial, which 12 impartial jurors would decide whether you're guilty or not guilty of any crime charged.
Yes.
You understand you can give up your right to a jury trial and allow me to sit as the fact finder and determine whether you're guilty or not guilty of any crime charged.
Yes.
You understand you have the right to be presumed innocent until proven guilty.
Yes.
You understand you have the right to have the prosecutor prove you're guilty beyond a reasonable doubt.
Yes.
You understand you have the right to have witnesses against you appear at trial and testify.
Yes.
You understand you have the right to question and cross-examine those witnesses through your attorney, Ms. James.
Yes.
You understand you have the right to call your own witnesses to court.
Yes.
You understand you have the right to have the court subpoena or summon witnesses on your behalf, requiring them to appear.
Yes.
You understand you have the right to remain silent at a trial and you cannot be compelled to testify.
Yes.
You understand you have the right to not have that silence used against you. So in other words, if you decided to proceed to trial and not testify, I would instruct the jury that they could not hold that silence against you. You understand you have the right to testify on your own behalf if you so choose at a trial and tell your version of the facts.
Yes.
And you understand that by pleading guilty, you're giving up all the rights that we've just reviewed.
Yes.
Other than the plea agreement and sentence agreement that have been placed on the record, does anyone promise you anything to plead guilty?
No.
Does anyone threaten you, coerce you, in any way force you to plead guilty?
No.
You understand that if I accept your plea, I'll be giving up any claim that your plea was the result of a promise or a threat, unless you tell me about it right now.
Can you repeat that question?
So you said nobody's threatened you, right?
Yes.
Nobody's forced you to plead guilty?
Right.
And nobody's promised you anything, so you plead guilty other than what we talked about, right? Okay. So you understand if somebody's threatening you right now or forcing you to do this, or somebody's promised you something other than what we've talked about you have to tell me right now, and if you don't, you can't raise those arguments later. You understand?
Yes.
All right. Are you pleading guilty voluntarily and of your own free will?
Yes.
Are you currently on probation or parole?
No.
You understand that by pleading guilty that you're giving up your right to appeal your guilty plea as a right, and even though the Court of Appeals may grant you leave to appeal, it is by no means obligated to do so.
Yeah.
You understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
All right, and to Ms. James and Mr. Bella, are either of you aware of any promises, threats, or inducements other than those already disclosed on the record?
No, Your Honor.
No, Your Honor.
All right, Mr. Bella, would you please create a factual basis?
Yes. Mr. Robinson, on the date of December 15th, 2020, were you at the location of 17197 Strasburg in the city of Detroit, Wayne County, state of Michigan?
Yes.
At that time and date and location, did you have in your possession an AK-47 rifle?
Yes.
And at that time, did you use that rifle to shoot, kill, and murder Mr. Hugh DeBose?
Yes.
And at the time you shot and killed Mr. DeBose, you did that with the intent to kill?
Yeah.
And that was deliberate?
Yeah.
Or satisfied?
Satisfied, Your Honor.
Having complied with Court Rule 6.302,
Yes, Your Honor.
all right, I find that Mr. Robinson's plea is understanding, voluntary, and accurate. I'll accept his guilty plea. We'll refer to the probation department for a pre-sentence investigation report. And we'll set a sentencing date of March 31st. Does that work for everybody?
Hold on one second. I'm sorry.
March 31st is fine with me, Your Honor.
That's fine. Yes, Your Honor.
All right, great. We'll see you on March 31st.
Yeah.
Thank you.
Are you ready, Mr. Miller? Well, this co-defendant's coming up.
Oh,
next.
co-defendant. That's right. Thank you.
Yep.
Have a good one. Thank you.
Week was that some- for that week, then this week, and I had 14.
Okay. Calling Case number 21-555-01-FC, People State of Michigan versus Dorian James. Appearances, please.
Good afternoon, Your Honor. John Bell on behalf of People P 68673.
Good afternoon, Your Honor. Jay Grant Miller, P58658 on behalf of Dorian James, who sits in front of me.
Sir, please take a name.
Dorian James.
All right, afternoon, James, Mr. Miller, and Mr. Vella. So today's the date set for a pre-trial. Where are we at?
Your Honor, we believe we'll probably have a resolution soon. If the court wants to adjourn this to March 31st, it's 2 weeks.
And we have been making progress on the case, but nothing I want to state on an open record in case we're on YouTube.
All right. Let me just. All right, yes, March 31st is good.
Thank you, Your Honor.
All right, see you then.
Thank you. Have a great day, Your Honor.
You too.
I like your green tie.
Oh, thanks.
Everyone have a great weekend.
That's
Happy
like
St. Patrick's
a
Day.
few times a year I actually wear it.
Yeah, this morning I completely forgot. I have a green tie too, and I didn't realize it, you know.
That's your great one.
I'm a little more limited because there's about wear this one, so.
Yes, well, my wife's entire side of the family is Irish, so.
No, I was raised Catholic, so